Okay, so welcome everyone to another episode of the Calcutta Lawyers podcast. This is season 2, episode 3 of the Calcutta Lawyers podcast. Um, your support for the last video has been immense, so a lot of thank you to all the viewers. If you have not viewed the last episode, I'll leave a card somewhere here. So today, we have Vikrant Pachnanda, and we're very excited to sit with him for this particular episode. So, welcome, Vikrant.
Thank you so much. Thank you so much.
All right. So, Vikrant, what I generally do while starting off an interview with one of our guests, so, I just go through what that particular person has done and how that helps. But while I was sitting down to do a little bit of research for you on you rather, uh, my cheats did not end. I mean, I did not know where to start and where to end. So I've just written down certain terms, and you can talk about it in whatever way you want. So there's JNLU
Right.
Gandhinagar, there is India Law Journal, there is Luthra and Luthra, there is Najmi Waziri, there is LLM from Cornell. I don't know whether you have a double LLM or not, because I've also seen
I,
an
I do. I do. I do. I do.
like, all right, and there's senior editor from for Standard Indian Legal Citation, Agarwal Associates, and IDIA also. You work for IDIA, and of course, you are an advocate on record from 2020 till today. So
That's right.
that's a lot of things that you've done in your in whatever time that.
I'm also an author, having authored one book and edited two books, and now writing my second book and fourth book overall.
All right. So just take us through the entire, because I've also seen that you've also studied in Don Bosco Park Circus, uh,
That's right.
in
That's right.
Calcutta, and then I think you did
That's
your
right.
high school from Delhi.
So I did my junior school from Chandigarh, my middle school from Calcutta, and my high school from there.
Okay. So
So I have a very fond and close affection with Calcutta. I have a lot of friends there. In fact, I represent a lot of clients who are based in Calcutta,
mhm.
and I do visit Calcutta 3-4 times at least a year.
Okay.
In fact, I was last there in Calcutta end of March this year.
All right. So, and then after high school, you sat for your CLAT, and you got admitted to
So there was
GST.
no CLAT during my time. In fact,
Okay.
you had to
Okay.
individually give law entrance exams for all the law schools.
For different law colleges. Right.
That's right.
And after that, you went on to do your masters, or the Luthra experience was somewhere.
So I did my 5-year LLB and from Gujarat National Law University, and then I worked for a couple of years, out of which I did 9 months with Luthra and Luthra law offices.
Mm-hmm.
I wanted to get a feel of a law firm environment as well as what corporate law is all about before moving to litigation, what I always wanted to do. So
Mm-hmm.
after doing that for around 9 months, I moved to the chambers of now, of course, a High Court Judge, Justice Najmi Waziri, who was then the Chief Counsel for the Delhi government, which is akin to the
Understood.
Advocate General of the states. But
Mm-hmm.
Delhi being a union territory, they don't have an official Advocate General. So I worked with him for a year and 3 months, and he got elevated after that. And I decided to go for my master's.
Mm-hmm.
And I'd already got into a few law schools, and I chose Cornell. And but while I was working with Justice Waziri, he also allowed us to independently take up our own briefs. So I was doing a few matters here and there while working, training, or whatever you call it, with him.
Mm-hmm.
And well, I did go for my LLM for a year to Cornell, but while I was there, a few of my matters were still going on. So I had a couple of people taking adjournments, and I was still, if on and off somebody wanted some legal advice or an email, that was something I was doing, working from there. We didn't unfortunately have virtual hearings, otherwise one could have perfectly done both,
Uh-huh.
uh, you know.
Yeah.
But nonetheless, the practice didn't, I would say, stop, whatever little bit I had started.
Mm-hmm.
And I came back, I joined Agarwal Law Associates under Mr. Mahesh Agarwal, who's a noted advocate in the Supreme Court of India. They're the largest filing firm in the country. And I worked with him for 5.5 years. But again, my arrangement with him was such that while I was working with him, I was allowed to independently take up my own briefs.
Mm-hmm.
I was allowed to do a second LLM alongside. And luckily, when I went to Leiden for my LLM, so Leiden has a 1 year program, but they allow aviation professionals who've got 5 years work ex to do it over 2 years and do it partly from their home country or wherever they are based, and partly from there. So you have to keep shuttling maybe 4 or 5 times for 20 days each time for your mandatory lessons. It was a regular LLM. You were part of two classes and you gave all the exams as them. So, because I had been associated with Leiden University since my law school days, they waived off that 5 year requirement for me. So, while I was with Mr. Agarwal, I was also shuttling to and forth, doing my masters from Leiden. And of course, the first 2 years was less of my independent work, more on the masters, because that took up some of my time, other than working with Mr. Agarwal. And once I finished that, I kind of focused more on my own work. So I was practically running my own chamber while working with him as well. And I'm still doing a couple of briefs here and there with him even now.
Mm-hmm.
But I officially, formally left him only last year in June.
Okay.
But again, I had already set up my own independent chamber much before that. He had allowed me to do it while I was with him. So I already had my own independent team and associates and support staff working in a separate office, and I would divide my time between his chamber and my office.
Right.
So, and while I was at Agarwal, I also ended up writing this book on aviation law. I edited one book on aviation law. I edited a book on space law, and I ended up, studying for the AOR exam, because the advantage of working in his office is it trains you perfectly well for the AOR exam, which is an exam where you have lots of drafting, and you need to be familiar with the Supreme Court rules. And I think working in his chamber is the perfect place to get all this practical experience of knowing the Supreme Court rules, knowing how to really draft, because you can't really learn up a draft and go for an exam. It's
Mm-hmm.
something that comes naturally, and over 5 years, 5.5 years, I did so much of drafting that when I had to give the exam while I was there, it came naturally to me. So that did help me clear the AOR exam. In fact, most of the people who in his chamber who actually have given the AOR exam are AORs today. So yeah, and then in the last 1 year, of course, I've been completely independent. Uh, but again, yeah, I mean, I've been practically functioning as an independent counsel thanks to Mr. Agarwal, doing both his work and my work since a while. So,
Mm. So just before we talk about your becoming an AOR and you're working for Agarwal as associate, what was your experience in the offices of Luthra and Luthra like? Were you interning there or were you working there full time?
so I worked as an associate. I did my internship there as well. I did 3 internships there,
Mm-hmm.
but all in different teams. And I did get an option, although my first preference was to join a council, but I managed to be. In my third internship, I was. They offered me they offered me, would you like to be interviewed for a position? I said sure.
Mm-hmm.
There's no harm giving an interview, and I got a call, and I said it's not a bad idea to get a feel of corporate law before I move to litigation,
Mm-hmm.
and because that is something I always wanted to experience as well, since one had heard so much of law firms and they were evolving when I was there in law firm day in my law school. And so I said, yeah, I mean, there's no harm trying it. Once I'm in litigation, I can't then leave and try it out. So it was always planned I would work for a year or so and try it out, and then move to litigation, which would be my where I would finally kind of be. But it's a good exposure. It taught you how to work how to work in a corporate environment, because today, even in litigation, you represent a lot of corporate clients, and I think it kind of sets out the etiquette, the manner in which you deal with a corporate client, as
Mm.
opposed to an individual when you're a peer,
Right,
as
right.
opposed to an individual who approaches you, how to communicate with them over email. Then of course it got me very familiar with contract drafting, because even as a litigation counsel, you have a lot of clients who will ask you, okay, we don't want you to draft this agreement for us, but yes, we want you to vet it and see if it is watertight from a litigation perspective, or is the arbitration clause fine.
Mm.
And that's where, because I was familiar with the contractual terms, with what are the boilerplate clauses in a typical contract, it was much easier for me to go through a contract and vet it for a client to quite an extent, because of having worked in a firm. It exposed me to a lot of new ideas of how you can do even litigation practice differently, because I got a chance to interact with the litigation team on a regular basis while I was there. there. So what does a law firm think from what does the litigation department think from a law firm perspective? How different it is. If when I was to leave corporate law, should I continue with the litigation department in the same firm or another firm, or go to a counsel? So I think it really kind of helped me. And more importantly, I had seen a lot of people, after doing litigation, regret, oh, maybe we could have gone to a firm, it's more glamorous, because obviously the pay is much better, the infrastructure you are in, the facilities are much, much better. And so I thought that, if I leave it after doing it, then I know I've, willingly done it, I've gone through it, and I'm like, no, I'm happy being in the courts and, in that kind of infrastructure, as opposed to a five-star environment that a premier law firm like Luthra had to offer. Yeah.
Yeah. So I think all experiences that we do, starting from our internship days till whatever offices and councils that we have worked under, always helps us. Uh, uh, the reason for me, I'm asking all you to break down your journey to, your journey uh, from a law student to becoming an AOR right now in the Supreme Court, is because of the very simple reason that a lot of us who are studying in, law colleges, and students who are also, some of us have also studied from state universities as opposed to the NLUs of the country. So a stark difference that we always see is that in the NLUs, for example, our student would typically do 10 internships over the course of 5 years, as opposed to the state university students, some of whom who do not even have an idea of which office to work with or where to apply. So yeah, so the Luthra experience should have definitely helped you. And uh, uh, so from that corporate environment, being pushed into working under a council who was working at that point of time for the state, or for the government of Delhi, uh, I believe that you guys were working, no, you guys were, so the perspective now has completely changed. You are into litigation. You're going to the court every day. So what was that experience like?
I think it's been phenomenal. In fact, I remember when I joined the council, he told me I can't pay you anything, and
Okay.
eventually started paying 5,500 a month. But yes, he says what you can learn from my chamber is you will argue my cases and I will sit behind you, and at the end of the day, I will tell you where you've gone wrong, where you've done well. And I
Hmm.
think that is what I was really excited at doing. And I think my moot court experience really helped, because I remember my first hearing, my senior was on his legs in another high court, and I appeared before that judge, and he was quite upset that my senior wasn't there on the first call. And for a person arguing course for the first time, I mean, sometimes it can send you jitters
Yeah,
or
yeah.
shivers.
Hmm.
But I was quite cool and composed, and I think that's where my mooting experience really helped me, because I was always an avid mooter in law school,
Hmm.
only because of the reason that litigation is what I always wanted to do. I always wanted to do what a traditional counsel does, and so yes, it was a different environment, but maybe because it was something I always wanted to do. I had done internships on the litigation side. I mentally knew what I was getting into when I
Hmm.
left the law firm. I remember my senior partner asking me at that time, oh, are you sure you'll be able to leave this environment? A, you're better paid. B, the infrastructure here, you're in an air-conditioned environment, neat, clean. It's like a five-star hotel. And when you're traveling also, we put you up in five stars. When you'll be doing your own matters in the beginning, you're working with a council, especially for the state. The infrastructure, obviously, in the high courts, the toilets and the canteen, obviously, is not as luxurious as what it is in a big firm. Plus, you travel for your own briefs in the beginning. Your clients will be small, may not be big corporate
Yep.
clients who
Yep.
can afford to put you up at a five star. So
Hmm.
that's fine. I mean, it's all part and parcel. I mean, if you have to be a counsel or a high court judge eventually, or an advocate on record in the Supreme Court, in a short, do traditional litigation practice, then there is no shortcut. At the end of the day, even the top counsels today, whether it is Mr. Hari Salve, Dr. Singhvi, Mr. Mukul Rodgi, I mean, when they're appearing in court, they are using the same infrastructure as what we are.
Sure. Sure.
Yes, maybe when they're traveling, they're staying in top class hotels because they represent top class clients. But again, I mean, they still share the same infrastructure when it comes to delivering and fighting for people's causes, fighting for their clients' causes. I mean, they're sitting in the same canteen as you during that 10 to 4,
Yes,
having
yes.
the same coffee. There's no coffee coming from a 5-star hotel, so there is no shortcut to that, unfortunately. You know.
Mhm. That's absolutely that's very well put. I mean, because I am also a practicing advocate at the High Court of Calcutta, so I see that a lot of my colleagues have actually shifted from litigation and gone into the corporate field. One of our mutual friends is being Jishujit Roy, whom you've
Roy, in fact, interned with me. Roy's interned with me, and he did a couple of work with me on a couple of briefs,
he
which
started
I would come
speaking
to
about
come.
you, and then that phone call never ended. Like, I had to literally
Right,
tell him that, all right, take it, I'll find out. So yeah.
right. No, I mean I mean litigation is very different. I mean you have to be attuned to facing a few hardships in the beginning,
Hmm.
and obviously it's not as glamorous like a 5-star hotel or like a law firm. But I mean everyone does it. There's no shortcut.
Right. So
Like
yeah.
even today, see, in litigation, you not only deal with fellow lawyers, you also have to deal with a lot of support staff, whether it is from your own office or whether it is from the court. You have
Hmm.
to also maintain friendliness with them, and no matter who it is, even if it's a top counsel, even he will have a good friendly relation with his own support staff, whether it is his clerk, his steno, whom he's dictating his
Hmm.
drafting to. I mean, they can't draft technically serious, but whatever, if he wants to better draft or whatever, and he wants to dictate some point, which the briefing council would then incorporate, or for that matter, something like that. So or even if it is maintaining a good rapport with court staff, with the court master. At the end of the day, so many times you see senior advocates walk into the room and they'll chat with the court master. Yes, what time is the judge sitting?
Hmm.
What time will he get up? So that kind of a rapport with not just people from the bar, but even from the support staff, the clerks, is something you keep even at that top level. Maybe yes, in the corporate sphere, you kind of are more in the corporate world. As you keep going higher and higher, you deal with higher people from your clients' corporate companies. But in litigation, even no matter how big you are, you kind of still maintain a good rapport with everyone, whether it is from your intern to fellow senior
Sure.
counsels, or judges who may have been colleagues with you at the bar prior to being elevated.
So did you?
So I think it also teaches you to be very grounded.
Yeah, yeah. I think that is. I think being grounded applies for whatever you actually do in life. So your masters. So the double masters that you have, one from Cornell and another from Leiden. So do you think that the experience that you had in those courses, did it actually help you in litigation at all?
So I think it may not directly help you. Yes, it does. It did help me doing an arbitration, because I remember I studied a course on international commercial arbitration, and when I
Hmm.
joined my senior, the first thing I told him is I want to do an international arbitration, and he gave me an arbitration to do in London,
Okay.
and my knowledge completely helped me only for that one case. But nonetheless, the overall experience has been very rewarding as far as Cornell and Leiden both are concerned. The way you deal with clients, because today you're dealing with corporates. As you keep growing, finding new avenues to grow your practice. Maybe if you're growing your office into a bigger chamber, or a firm, you have friends in that jurisdiction whom you could maybe try and figure out if you could
Mm-hmm.
work on a cross basis. So all these ideas, see, they're all things that there's no sure shot response
Or
or
a
a
formula
solution
person. Yeah, yeah.
that you that is there immediately. It is something. It's all hit and trial, and definitely, if you get the chance, there is no harm exploring it. It is hit and trial, and but yes, at some point of time, they say education never goes waste. As far
Mm.
as the air power is concerned, aviation, in fact, has always been my passion. My first love has always been to be a pilot, because
Okay.
aviation is where lies my heart. Whether it has been watching movies, it has been watching documentaries, or it has been playing computer games, it's all been aviation related right from my childhood. I love traveling. In fact, that's what I really enjoy about being a litigation lawyer, that I'm the master of my own vacations.
Yes, yes,
Um,
yes.
and that's something I really enjoyed, but because I have air sickness, I could never be a pilot. And while I was at law school, I discovered Leiden University, and it has a course on aviation. And it was something I always wanted to do, more like a passion. I'm still actively involved. I do some aviation related policy work, some aviation disputes, especially last year during COVID. We had a lot of claims from clients because airlines weren't refunding money, travel portals, travel agencies weren't refunding money. So there was a little work to keep us occupied there. And I'm academically very involved. I teach at universities. I judge an annual moot court competition of the university, which of Leiden University, which is held annually in a different part of the world every year, and is the only annual moot court competition of its type. I speak at academic events. So I am academically involved. I've written 3 books in that field, edited 2, written 1.
Mm-hmm.
So I mean, it's something which keeps me going. I mean, alongside
Yes.
litigation.
Yeah. I think the biggest takeaway from whatever has been discussed till now, I think the common factor that I see in whatever you're saying as a pattern is that you have kept on, working and hustling through whatever you have done, and I think that's an extremely inspiring thing for any law student who's watching this particular video. So, yeah, so the most number of questions that I've got before doing this particular interview, and for every interview we have this WhatsApp group where we say that this particular person is coming. If you guys have a question or so, hit us up with it. So the biggest and the most voted question that we had is first. So this is two parts. One is who is an AOR, and second, how can I be one?
So what happens as far as the Supreme Court is concerned? I believe Calcutta also has a system of an advocate on record for
Yeah,
filing.
yeah.
But at least as far as Delhi High Court is concerned, you don't need to be an advocate on record as long as you're registered with the bar. You just need to register with the High Court
Mm-hmm.
and get your e-filing number, and then you can file in the High Court. High Court doesn't have a rigid system of an advocate on record for filing a matter. But
Mm-hmm.
yes, the Supreme Court does have a system of the advocate on record. If you want to draft a matter and file it in your name in the Supreme Court. And so that is what an advocate on record does in the Supreme Court. He basically drafts the matters and files it in his name. And then he can either argue it himself, or he can engage another advocate or senior advocate to argue the matter. But he's the one who essentially controls the matter, in whose name the filing is done, in whose name the wakalatnama is executed. And he is your lawyer on record as far as the Supreme Court is concerned. To become an advocate on record in the Supreme Court, it is not an easy task. You have to give a 4-day exam, which
Mm-hmm.
is quite grueling. Pass percentage is very, very low.
Yeah.
And you have to give an exam in 4 topics. One is legal drafting, one is Supreme Court rules, one is leading case laws, where they give you a list of 40 cases 1 month before. And it's an open book exam. They give you this. They give you the head notes of all the judgments,
Mm-hmm.
but it's not easy looking for the facts in between. And then you have ethics. Now, if we take subject by subject, drafting is something which is not very easy, because A to what are the criteria to give the exam? You should have already had 4 years experience as a lawyer, including one with an advocate on record in the
Mm-hmm.
Supreme Court. And when you start working with the advocate on record, you have to submit a letter from that advocate on record saying that you have commenced your training, and you have to submit that letter in the Supreme Court. Supreme Court acknowledges that, and they tell you, okay, after 1 year on this date, you have to give a completion certificate. When you
Okay.
give that completion certificate, then you're eligible to sit for the AOR exam. And of course, you have to have minimum 4 years. So
Mm-hmm.
eventually, after 5 years of practice, you are with that 1 year training period of with an AOR minimum, you are
Mm-hmm.
entitled to give the exam, sit for the exam rather. Now, if you look at the subjects, the first subject I would take is drafting. Drafting is not easy, which is why you need the 1 year experience with an AOR. I know a lot of people get certificates written from an AOR if they know them personally, but that doesn't help, because why isn't it they want that experience? Because drafting is something that you can't mug up. It comes naturally, and it's only when you're working with someone for a year at least does it come to you naturally. Because what is the format? Because there's so many different type of matters you file, whether it's a special leave petition, it's a civil appeal, it's a transfer petition, it's a criminal appeal. There's so many different kinds of it's a writ petition. There's so many different kinds, and each one has their own format. And when they ask you a question, in some matter they may say, okay, draft the entire petition. In some way they say, okay, only draft the grounds. In some way they say, only draft the prayer. Now, the thing is, you have to be abreast of the laws, because today you're drafting a petition and you're asked to draft the grounds or draft the entire petition. You would want to rely on some case law, or at least the ratio decidency of a case law to prove your, to,
Sure,
to
sure.
the kind of case.
Hmm.
And that does help you get extra marks. You don't, it's fine, but that helps you get extra marks. And I think that's what kind of
So there's
you,
this because
that kind of helps you in the drafting. So drafting isn't very easy, and you get five, six questions, five, six assignments to draft during your exam, 3-hour
Mhm.
exam. So it's not very easy. Then if we look at leading cases, in leading cases, they usually give you a list of 44 cases 1 month before the exam. You have the list of cases, the head notes are given to you during the hearing, but you need to read the exam, because what they will do is they will say, okay, this is the thing. What was the minority opinion given by Judge XYZ in this matter? And suddenly, in that short span, to start looking, you have a book which is this thick. It's all in front of you, but you need to know what is where.
Yeah.
And all these 44 leading cases are judgments where each judgment is over 100 pages.
Mhm.
Like Keshav Bharti, for instance. So now these kind of judgments where you have 5-judge bench judgments, 3-judge bench, 7-judge bench, to look for, or they'll give you a proposition. This proposition, who mooted this? Was this dissenting, or was this a concurring, or was this the only judgment delivered? So you need to quickly glance through your judgment. So you need to know this in advance. So it's not very easy learning on the spot. So you need to be familiar with the judgments, read them a few times. So then when you're talking about the Supreme Court rules, again, just mugging up the rules doesn't solve your purpose, because, you need to be familiar with how the registry functions, because as a Supreme Court counsel, you're not just drafting, but you're also doing the filing. It is mandatory for a Supreme Court counsel, AOR, when he's registering, to give proof that his office is within 16 kilometers of the Supreme Court, and he has a clerk. If he doesn't have a clerk, he can't register as an advocate on record, even if he has cleared the exam. And your clerk is registered as well. A clerk also has a qualification, by the way, minimum 12th pass.
Yeah,
So
yeah.
the
Same
clerk
for us.
also has a qualification for the Supreme Court. For the High Court, there is no minimum qualification. I don't think there is. I may be wrong, but I don't think there is. But for the Supreme Court, there is. So, you have these ruling in, so Supreme Court, again, you need to know, you can't start mugging up, okay, when you file a matter, it goes to this person in the registry, he scrutinizes it, it takes this many days, this is how, you can move before the vacation bench. A lot of these things are things which are practical oriented, which is where, again, your training with an advocate on record for 1 year really, really has to be taken seriously. The last question is ethics. Now, ethics is a very, very broad topic. It can come, it's something which you kind of, gather over the years. Like, I can tell you one question. I remember there was that controversy during my time about, ex-president, US President Donald Trump having an affair or something with with his ex-lawyer or something like that. And we got a question, John, if supposing we got a question on those lines. They didn't directly refer to them, but it was on that lines. If he was to give client attorney privilege to so and so, the police came and questioned you, to what extent can you disclose the language? To what extent can you disclose the communication? If you don't, can you be prosecuted? So those kind of practical, tough questions. And or for example, if your client tells you to do something, are you bound to do it? Are you the mouthpiece of your client? Or for that matter, can a lawyer strike? Under what conditions is he allowed to? On what conditions is he not? So again, it's not very easy. It's a 4-day grueling thing. It happened in the second week of June. Supreme Court shuts only mid-May. So you practically just get 15 days in May and maybe 1 week to 2 weeks max, if it happens mid-June, to actually prepare. Yes, we have senior advocates who take your lectures, and the lectures are very helpful if you attend them in May. They usually have it in May or June, May actually, towards the end of May. And a lot of times those counsels are your examiners, so they are very helpful by broadly giving you some case laws to specially focus on. Not to say that is the syllabus, but yes, lectures are important because they do help you to quite an extent, and they give you clarity on how to prepare, since you have a short time to prepare. So that's how you become
these
an.
lectures are organized by the Supreme Court. Uh,
That's right. The Supreme Court organizes these lectures. That's right.
all right, and anybody who registers for this particular examination is
Even if
registered.
you're not registered, you're free to come and attend the lectures. You're free, but the lectures are given from an exam perspective.
Right, right. So that that office, having an office and having a clerk, that is very somehow reminds me of the original side practice in the High Court of Calcutta, where we also need
Right,
a registered office within a
right,
certain jurisdiction. So
right, right, right.
so okay, so okay, so that's broadly breaking down how one can attempt to at the examination of the advocate on record, and it's one of the toughest examination in the country. And as you have said, that it's not very easy to get in through that particular examination. All right, so so the concept of just to a little just to hit upon the concept of an AOR. We also have AORs in the Calcutta High Court, right? And we don't sit for examination. We most of the junior advocates, they are often made the advocate on record. And as you said, that the work of an advocate on record is basically to start doing the drafting and then file the case, and he holds the strings to the case. So, but how is that? What I'm gauging at is that what is the how is it so much different from that of the Supreme Court AOR, as to that person has to sit for such a rigorous examination and then do so much of studying, and yeah.
I'll tell you, the thing is, the Supreme Court, is the last court of appeal. The judges don't really have time to, start spoon feeding you if your drafting is not proper, or you're taking new grounds which is not acceptable in an appeal, unless of course you actually have a separate application to permit the same, explain the reasons. So they want, so when you've cleared this exam, you know exactly what the judges are looking at. They know
Hmm.
when you're drafting, your draft has to be in what order. You're familiar with the whole system of filing. You're familiar with it because you learn the Supreme Court rules. You go through drafting a drafting exam. Ethics is something the Supreme Court really upholds. Not to say other courts don't, and they want you to be well versed with ethics. And kind of in a way to also remind you that ethics is something we lay a lot of emphasis on.
Mm.
And lastly, a lot of constitutional law cases are filed in the Supreme Court, and new points of law are set out on a daily basis, and that's why it's important to be abreast with the latest laws in the Supreme Court, because at the end of the day, Supreme Court decisions aren't binding if it's the same bench. Like a majority of your Supreme Court decisions you cite on a regular basis will be a two-judge bench judgment.
Right.
Not every judgment would be seven-judge, five-judge, three-judge. They're not binding on another two-judge uh,
Division bench. Yeah.
bench.
Yeah.
Right. So, to I think get you attuned with all this, which is why I guess they have that rigorous system. I believe I do remember reading about a few years ago somebody challenging it, and it was struck down.
All right. All right. Okay. All right. I think that creates a perfect segue for the next question. So, because we have already had such, an extensive experience both in the corporate sector and also in the litigation field. So there's
Right.
a saying that we were taught in the final year of our graduation, that anybody who walks through your doors, you cannot say no to them. Anybody who actually approaches you, you cannot say no
Right.
to them. Do you think that's fair
Right.
and practical in today's the practice, the way we see
I
it?
think I think the whole idea behind this is that our profession is a very noble profession, which is
Hmm.
why even advertisements till date have not been allowed in India, even though in several countries such as the United States, for instance,
Yeah.
lawyers can advertise their services, and even on taxis and buses you see advertisements of lawyers.
Hmm.
So we are a noble profession. It's something where people come to you through word of mouth, through the expertise, the reputation that you gain in court, and you're there to do justice. And being in the noble profession, you should not say no. So I think that's the whole idea behind this concept, that you don't say no. In fact, pro bono cases is something that is now even more encouraged, because if you look at the justice, if you look at Ms. Indra Jaisingh's judgment, which lays down the guidelines for becoming a senior counsel,
Hmm.
doing a certain amount of pro bono now is also a mandatory requirement, and you get points for it in that point system that this judgment devices to be eligible to apply for senior counselship. So I think that's the whole idea behind this.
Hmm.
Although unofficially we know that clients do their own homework as well, and they know if we are going to if we are stepping into a senior advocate's office and we can't afford the fees, we should be prepared to be turned out. In fact, which is why today, you can't. Nobody really walks into an office. If you're, especially if you're engaging senior counsels, you first check with their office what their fee is. You tell it to the client. You get it approved by the client, and only then you actually tell the client, and then take an appointment or a conference time with the counsel.
All right. Vikrant, is there a connection problem on
I
your end?
just a second.
Yeah.
I think now we are okay. Yeah.
Yeah. Yeah. So yeah. So right now the way litigation is working, we have, because of the pandemic, we've shifted to this the virtual mode. And like you said, in the before we started recording this program, we were talking about how you visited the office only, 2 or 3 times this in a long time now. So a hybrid system had been started. I can tell you from the perspective of the Calcutta High Court, a hybrid system had been started last year, where after the first wave, we had gone into an hybrid mode, and physical physical appearances were being allowed. And because of the second wave, again, restrictions have been imposed upon. And I'm sure that, like a lot of us optimists, you also believe that this particular pandemic is not going to last forever. We're going to recover from it. And so now that we have been, well acquainted with the virtual system of hearing, do you think it's going to be a norm?
So I think it's not going to be a norm. We are going to have, eventually we will get back to physical when the situation improves, when a majority of the people in the country are vaccinated, because which is clearly a message from the Supreme Court. And when which many judges have said in various lectures that they've given at different forum. And because see, at the end of the day, it is an alternate, but I don't think it can be a substitute.
Hmm.
It does
No,
no
why,
doubt
why,
save a lot
why,
of.
why, why do you say that? Because my
So,
question, and
for example, you can't do evidence in an e-system. It is extremely difficult, which is why evidence isn't happening. In fact, all your trials have suffered only because of
true,
this.
true.
So that is something. So evidence is one thing.
Hmm.
Secondly, even when you're not arguing on evidence, say you're arguing on merits, if a lot of times you have matters where you have multiple counsels involved, it's very difficult to do it virtually. And if you are briefing a counsel, it's not always very easy, briefing a counsel virtually and doing it, because right now, at least in Delhi, if you're briefing a counsel, also you're briefing him over Zoom. You're not going to his office or his house to brief him. And during the hearing, and a lot of senior counsels were used to, a lot of support from junior counsels, briefing counsels, while they are arguing in terms of research material, what if they've left out some point. And virtually, it's not very easy conveying that, over an SMS. I mean, either the counsel is looking at his screen arguing, or he's looking at his SMS. And definitely that counsels also, who were more reliant on briefing counsels, have to kind of learn to be self-reliant for the time being. And so even for counsels, I think many of them prefer the virtual thing. And I also think personally, uh, I think trying to put your pleading before a judge, trying to convey your point, is much easier in a physical court as compared to virtual court. Plus, in a physical court, a lot of times, you want to hand over judgments, you want to hand over one-odd document. The courts are very liberal in allowing that. Whereas now with virtual, you really can't hand over everything. You need to request the court for screen sharing. In High Court, Supreme Court, if you're looking at sharing documents, you need to 24 hours before, the protocol in place, and you need to spend a lot of time focusing on these logistical issues, which you don't need to do in a physical hearing.
But
Like when I'm doing a matter in the Supreme Court, I need to first think, okay, 24 hours before, I need to send my list of judgments to the court master. I
mhm,
need to follow, see, is it before, because the judge is sitting in his house doing the hearing.
true.
Whereas in a physical court, I don't have to worry about that. So I can focus on other things, whether it's looking into the merits of that very matter or another matter. But now I need to spend a lot of time working on these logistical issues, especially as a filing counsel. whether it is in the Supreme Court or in any other court. Because I know I can't hand over documents across, or I can't tell the judge this is the citation, and the court master takes it out from the galley where the SCCs and AIRs are lying and just gives it to him. Or for that matter, even takes out the Bare Act and gives it to him. He needs to have everything downloaded on the system in advance. So that last minute preparation which I do, a lot of times you have to think, okay, how can I get this across to the judge? I found this last minute judgment, but I need to figure out a way to logistically also share it. So I don't need to really focus on all that and break my head over it.
True, but at the same time, Vikrant, there is also a recent picture had actually leaked on the internet. I'm not going to take the name of the senior counsel, but he was appearing, I think, from his home, and he was seen.
I think we both know who we are. I think we probably both know who we are.
Yeah. So,
but I think that is all about, I think, self-discipline. Maybe the courts really can't enforce. You can't have a 360-degree camera from where you're doing it. They can only see the top part, and for that they've already said, the bar council, okay, you don't need to wear your coat, you just wear a white shirt and a band, and that does it. Of course, you need to, if you are, taking advantage of the fact that the bottom part, only your top is going to be visible to the judge, and you want to take advantage of that fact, and which is fine. As long as there's no disrespect done to the court, and that is that particular counsel who's appearing to make sure that I don't disrespect the court. And yes, there are times, I'm not saying that if it's done intentionally. Nobody intentionally would do it. But then yes, you have to be mentally prepared that sometimes, especially like, for example, I know I'm not a very techno savvy person. I know my camera goes here, there. So I know I need to be a little more careful with what I'm saying, and to make sure I'm with muting and not muting, and making sure my camera's in place. Somebody who's more tech savvy, maybe for him, he's like, I know how to handle it, So I know, so that's something which you have, which is in your hands, and as long as you have that in control, it's and you're not disrespecting the court, then I think it's okay.
No, but the flip side of that same coin, but the flip side of that same coin is the fact that if you look at that particular picture that we were talking about, you would see that learned counsel was sitting in front of 3 screens, and he was appearing. I know for a fact that he was on that day. He was appearing for a matter in the High Court at Calcutta. He was also doing a Supreme Court matter on that day as well. So what I'm trying to gauge at is that I completely agree with you on the physical court thing. That even I would prefer, submitting before the judge physically. But if we actually slowly start at Hari Salve, Mr. Salve being one of the examples.
Right, being in London, he's appearing from there. I think, yes, it no doubt saves times. You can do multiple matters. I have been myself regularly appearing before high courts outside Delhi without having to travel, and doing my Delhi matters alongside. And plus, I catch up on office work and drafting and things like that. It does save a lot of time, no doubt. But then at the end of the day, you're a lawyer not for convenience purposes. You're a lawyer to ensure justice to a client. And if in my opinion, I would say that if a physical hearing is more effective in giving justice to your client, then I think that has to be given precedence over convenience purposes.
So do you think?
See, the pros are that it is convenient. The fact that I can do 3 hearings alongside without missing my matter is convenience for me. But at the end of the day, when I'm a lawyer, it's justice first and then convenience, not the other way around. So the justice cannot be compromised at the cost of convenience.
Fair.
That is how I look at it. That's my personal opinion.
Yeah, but the fact that
it saves time, it no doubt saves time for everyone. Even for me, it saves a lot of time. Sitting in the office, even doing local hearings, I can do so many in one go rather than spending the whole day in court. And I can then do my office work and wrap up by 6 in the evening, focusing on other things or whatever not. Or not waiting till Sunday to catch up on pending work, but doing it during the week because I get free from court early. And that way is getting Sunday to spend with my family. It is very convenient, but that is all convenience. But at the end of the day, the question is whether that convenience comes at the cost of justice. Like, for example, doing that, but not being able to have evidence being led for a client virtually, is convenience at the cost of justice. But that is something we can't afford. So as long as, so it's very important to, at the end of the day, know why are we there. We are there to uphold justice, to uphold the law, to act as an officer of the court, and that comes over, that would lay any day precedence over convenience. Otherwise, we're all very used to sitting in the comforts of our homes. We don't even need to go to the office. I mean, we've just discussed. I mean, I've come. I'm sitting here in my office probably for an hour or two, and it's only the second time that I'm sitting in my office since April. It's very convenient working from my house. But at the end of the day, I have to make sure that convenience doesn't come at the cost of justice. Today, I'm here in the office because I have some work which I can't do sitting at home.
True.
So I have to put my convenience aside and look at justice.
But my point in this entire discussion is that for people like you and me who would prefer a physical hearing, I understand that I definitely want us to go back to that particular system. But do you think now that the virtual courts are here, a hybrid form of appearances and filing, and the online option being open, just to be
So I think a hybrid form is very good because that gives you the flexibility to do both.
right?
That gives the flexibility to do both. You can appear physically where you want to, and virtually also you can. Courts, at least in the Delhi High Court, they've made a room to do hybrid hearings. So if you're appearing physically in one matter, but the next matter you want to do virtually, you can go to that room, sit, carry your laptop with you, and do it virtually. They also have computers there themselves, as everyone may not have a laptop. So I think a hybrid system is definitely a positive step because that gives lawyer the option to choose between convenience and justice, and make sure justice is not compromised at the hands of convenience.
True. Yeah.
So where the lawyer knows justice can be done with convenience, you have that option as well. And where justice can't be compromised because of convenience, the hybrid gives you the option for that as well. So I think definitely hybrid is no doubt a good is no doubt a positive step in that.
Okay, so I'm a little conscious of the time. I'll not take a lot of time. I will end this particular thing with two questions. Uh, One is, Vikrant, one experience or a case or something that has stuck with you for the longest time. It might be a case, an experience with a client, or a pleading, or during your college days. Anything that you have taken away from your journey of becoming an AOR, the lawyer that you are today. One
So
such
I
experience.
think being an AOR has been very, very helpful for me. I mean, why I would say that is because I think it kind of gives you extra ammunition. Because at least in Delhi, how we function is we don't really, I mean, you have lawyers who might decide, okay, we're doing counsel practice, somebody who maybe does only filing. But broadly, unlike Calcutta and Mumbai, we don't really have that distinction in the first few years of practice between a filing counsel and an arguing counsel. And you end up doing both, which is why if you look at the biodata of senior counsels who have been who have been designated by the senior advocate by the Delhi High Court, as well as honorable judges profile of the Delhi High Court, many of them have been advocate on records before either being elevated as a judge or being designated as senior advocate. So at least in Delhi, we don't really have that clear distinction. And how we normally work in Delhi is, you kind of have both, and then you can take a call maybe as you keep progressing in life whether you want to become a filing counsel or an arguing counsel. And I think it's helpful, especially for a first generation lawyer like me, because technically second generation, because my dad has studied law but doesn't practice, but nonetheless in practice of first generation.
You're a first generation, yeah.
And it is helpful because not every time will I get a brief to argue, but there are times where a client does come to me. He only wants to file, but I'm open to that. But at least I get to be part of a matter, and I get to learn when a senior counsel is being briefed as well. So that way, being an advocate on record has been very helpful because I get to be part of a matter, even if, especially at the Supreme Court level. See, stakes are very high. We don't have the concept, and again, I know the Calcutta system because I do a lot of briefs from Calcutta. We don't have the system of a senior counsel and junior counsel. It's just your filing counsel who's a briefing lawyer and a senior advocate.
Right.
So, and when you're on the Supreme Court, not everybody wants to give a junior lawyer the matter to argue because it's the last level. It's a final court of appeal. You really don't have anything up beyond that. No
Hmm.
remedy beyond that. Of course, you have review and curative and all, but again, scope is very limited for those, and nothing beyond that. So, especially for a first generation junior counsel like me, it's not always easy getting into a Supreme Court matter if I'm just relying on being engaged as an arguing counsel. Because we don't really have a concept of a junior counsel,
Hmm. Hmm.
which I know you have in Calcutta. But if I'm an advocate on record, I still get a chance to be part of the matter, because while somebody else may be engaged to argue the matter, I still have a chance to draft the matter, to file the matter, be a part of conferences, thereby learning when we are briefing the senior advocate. So that is the advantage, I would say, and which is why I say it's extra ammunition you have. I have a lot of matters which I've been able to catch on only because I couldn't have been engaged as an arguing counsel because of stakes involved and being the final court of appeal. But because I had this extra ammunition, clients say, okay, yeah, we are okay with it. Some clients even said that, we will draft it. But yes, for filing, we need an AOR. So even if it's just for filing purposes, I still get to be part of a matter and not just sign a mere document. At the end of the day, I have to read what is being filed because it's
Hmm.
going in my name. Or the judge questions how it's been drafted, it comes upon me. And moreover, I get a chance to be part of briefings with senior counsels in that particular matter. So I'm also learning. At the end of the day, law is an evolving field, and you're learning every day as you keep, irrespective of how senior you keep getting.
Vikrant, are you a 24/7 lawyer? 24 into 7 lawyer? Are you a lawyer full
Uh,
time, like
well,
every day? Every...
unfortunately, in our practice, it's a word of mouth profession, and you need to be accessible 24/7. I have had times where I've had a client calling me at 10 o'clock at night. Now I have two ways of thinking. One side of me says, let me call him back tomorrow. Why is he calling me at 10 o'clock at night? But then the second part says, what if he's engaging me last minute for a new matter? I don't know that. And if I don't call, he'll give that to somebody else. And next time when he has last minute matters, he will always go back to that person whom he's hired, because he says this guy doesn't take his call at 10 o'clock. So you need to be 24/7 available to a client. I mean, yes, I do. I have a life beyond law. I wouldn't say I'm confined only to the chamber, but yes, you need to, especially if you're an independent counsel. You're calling the shots in your chamber. You are responsible for the
A lot of
for
things.
engaging with clients in your chamber, responsible for getting the work to your chamber. So you need to be 24/7 available. You don't know when your next case is going to come.
So just the other day, I was drafting a particular petition with my senior, and we were, vetting an already completed draft, and it was really late into the night. I think it was 12:45 or 1. We were awake till then, and a particular person kept on calling this senior of mine. I think he had called 13 or 14 times. So the first reaction was just like you had said, that why is he calling me at this such a strange hour? I can always call him back tomorrow. But so at one point of time, because we do criminal practice, so it just hit us that this particular person might be, escaping police or something of that sort. Maybe the police has, reached his house or
Correct.
something of that sort. And that's exactly what it turned out to be. He called us up and said that I'm hiding
Sometimes the
somewhere.
next day is too late. Sometimes the next day is too late.
Yeah, yeah. So I think, yeah, that's pretty important. All right. So just before we end, um, the biggest advice that you would give to any law student from whatever you have learned through your journey.
Well, I think just focus and do what your heart says, and just focus at it. Be honest to yourself. Be honest to the profession, and leave the rest to God.
I think that's a great way to end this. I can't thank you enough for doing this, for taking time out, and I learned a lot of things. I hope that the people who will watch this video will also learn a lot of things. I will leave the links to how to get in touch with Vikrant on in the description box. I'll leave his LinkedIn ID. I'll leave his
Please
mail
do
ID.
share the interview with me. I would love to see it myself. Please
Of
do share the
course, of
interview
course,
with
of
me. I would
course,
love
of
to
course. We'll
share
finish
it.
this up, and we will share it with you. You can get in touch with Vikrant if you guys want to. Acha, Vikrant, do you take interns? Does your office take interns?
We do take interns, and right now because of everything being virtual,
Mm-hmm.
we do take interns on a virtual basis as well. So if
Okay.
you're interested, feel free to email. My email is vikrant.pachnanda@gmail.com,
Mm-hmm.
and somebody from my office will definitely get in touch with you.
Brilliant, brilliant. So I'll leave also link of that email ID in the description box below. Uh, Thank you, Vikrant. Again, thank you so much for doing this. It was
Pleasure is
really,
mine.
really,
Thank you so much. All the best, and stay
yeah.
safe in these COVID times.
All right. Thank you so much,
And I'm sure
Vikrant.
we'll get a chance to maybe meet when I'm in Calcutta next.
We will meet. We will definitely meet when you're in Calcutta. And along with Roy, the first name of who you cannot
Sure,
take. I've heard that you cannot
sure,
pronounce his
sure.
name.
Absolutely, absolutely,
So yeah,
absolutely.
we will
Thank
meet.
you so
Thank you,
much.
Vikrant. Thank you so much.